sentence investigation report?
I have your honor.
All right, Mr. Brown, have you?
I just have an item, let Mr. Mason see it removed.
Oh. Thanks, sir.
There's nothing to do.
All right, Mr. Mason, what do you want to say on behalf of your client?
Your Honor, Cooper's 20 years old. Obviously made a big mistake here. Ended up pretty severe injury. I have to say, he's been very cooperative with me. I know he was cooperative with Officer Dell from the first day. He actually went to juvenile court. The officer had filed charges against 2 other individuals. He was there to participate in that trial. Your Honor, he is working. I guess it's Jimmy John's still in the construction apprentice. Where is that? Okay. Your Honor, his parents are divorced, but he does have support from them. Currently, he's living with his grandmother. Hopefully, he's already turned the corner and he's going to be compliant with whatever terms that you might require of him. I don't believe he has any substance abuse issues. At this point, hasn't had any problems with being out on bond. And I'd ask you to consider a suspended sentence.
All right, thank you. Is he on you?
He has been, are you still on? Yes.
All right, thank you. State,
Judge just concerned about given his age, his criminal history. From reviewing his record, it looks like he previously had trafficking charges that were reduced down from a felony to a misdemeanor, and also the allegations in this case, because it's not something he was charged with, but it was that at the time he was conducting a drug transaction when this felonious assault occurred. The officers did not charge him with that, given that he did get shot at that time. But given all those facts and that he is charged with an F4, I'll protect the court as far as criminal sentencing.
Ms. Jansen, anything you want to say before I pass sentence?
No.
You have that he was, has a criminal history. I have that charge was dismissed.
I believe
The misdemeanor charge?
there's misdemeanor charges. I thought it was reduced from a felony, and then he was guilty on the misdemeanor. Let me see.
To the OBI. No trafficking or anything like that. Young man, you indicated in the PSI that some people owed you some money. You thought they were gonna rob you, so you got it done, right? Obviously, these people that owed you some money were your friends, correct?
No.
And so why would people who are not your friends owe you money? You were hustling? Helpful. You were helpful. So you just give strangers money.
They weren't strangers, I lived around.
Um,
He had I know he had a girlfriend at the time, who I think knew them. I think that may have known it all.
You know,
Okay.
yeah, he doing something he never gets to. That's the reason, right? Yes. And you got shot. Right? All right, well, young man, I'm just gonna tell you, is that life? You obviously already got that life. You're not good at it. So you need to stop. Otherwise, you're gonna get killed. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors as set forth in revised code 2929.12. Accordingly, young man, I hereby sentence you to a term of 1 year of community control, basic supervision. You will pay court costs, there'll be no fine. There will be an order to forfeit the firearm. Let me tell you something. You're on a short-term probation. I have the authority to extend it up to 5 years. But I'm hoping that you'll get your life together and quit these shenanigans that you're involved in and move on. So I'm going to give you a 1 year term. However, if you violate the 1 year term, I'm not extending it up to 5 years. I'm sending you to prison for up to 18 months. Do you understand?
Yes.
Which, if you can't handle what's out in the streets, you really can't handle what's in prison. So, I suggest you take this opportunity for the next year to get your life together. All right. Anything else, counsel?
No, Your Honor, thank you.
Nothing else.
All right. You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand? All right, I'm terminating the EMD. You can go over to the EMD office and get that off, but you will be on probation. I suggest you fly right. Thank you. Yeah, straight to probation.
I was gonna say, does he need to?
Straight to probation.
Thank you.
All right. Anybody on the 10 o'clock docket ready?
Your Honor, do I have 5 or less than 10 minutes to run up to Judge Karen's district council?
Yeah, and then the jury questionnaires are ready, so I can give those to you.
I'll be back in 5.
Okay.
Thank you.
Mr. Dean Chinzo, yeah, Mr. Coleman, your client here. Okay, and you're ready for your trial, but the victim isn't here. Right. Okay, you got 15 minutes.
for.
Yeah, I know these people, I need to swell.
As soon as Crystal walked in, they're done working on trying to get me honest.
Okay, because we don't, they were names. Swell.
Do I know it's before long, but is there?
Yeah.
That was Friday, it could be number one.
You were still still maintained. I could have been. You have energy.
Come over here, Chris, that's on that's,
It's so long. There's a tree.
Yes.
Like, it's all in business.
Just to give you a the heads up. Explain to you what's the price. He said, I've never had a situation like that. It's true. We just haven't had a chance to really talk about it till now, but it's true that he's been sitting there the whole time and he's never had one. So that's his optic. So,
Mr. Prosecutor's not here. Mr. Goldberg, I'm going to give you the jury questionnaire. And we'll give Ms. Colson hers when she gets down.
This,
Carol, can you put this in? Yes. Mr. Goldberg gets copy.
That you don't, it doesn't matter if you figure it out.
All right,
Just one thing.
Mr. DiVincenzo, Mr. Coleman, was that the prosecutor going out with the victim?
Yes, sir.
Okay. Mr. Ernst, you ready?
Judge, I apologize, I was running late this morning and I didn't be formed. If I may, I'd like to get signed.
Yep. I'm ready at the trial. You know,
Okay.
everybody's gonna be pushed to the day if you don't get it done. Let's go.
Yes, ma'am, I apologize.
That's okay, thanks. Ms. Lake, do I have the key forms?
I have it. I had to sign by myself and my client, but just needs to sign.
Would you say, Ms. Lake, Ms. Lake?
They're signed by me and my client. Just needs to.
You need Ms. Brown to sign? Okay. Well, I'd like to at least see it first, so I won't have to be the last to see it, and have to. Labor, you can be asking for, PSI?
No, I can leave the second to that if you're able to do that.
Here you go. For Mr. For the prosecutor. to sign. Thank you.
Sure. Okay, thank you.
He's looking at, still juror.
And then do a PSI assistance.
You are?
Yes. All right, you ready to call, Ruffin?
Yes, Judge.
This is a matter of State of Ohio versus Edward Ruffin, case number B 2400562. Mr. Ruffin is present in the courtroom with his attorneys, Ms. Courtney DiVincenzo and, Mr. Cole. I know, Christopher Cole, I want to say your first name. And Mr. Brandon Brown from the State of Ohio. This matter is set for jury trial today. Are we ready to proceed?
Yes, yes, sir.
All right, so, have there been any, discussions to resolve this shorter trial?
There have been, Judge. We initially explored the option of having this pay restitution in exchange for dismissal. The state countered with the potential misdemeanor offer with restitution, and Mr. Ruffin has declined to accept that.
Okay, all right, and, we want to still proceed with the jury trial?
That's correct.
All right, well, stay tuned, we'll see what, I have one ahead of you, but not sure what's happening, if it's going or not. We do have a panel ready to try a case, so let me just, have you sit tight just for a moment so I can see which one is going first. Okay? Thank you.
Sorry, I know there's another case. I'll talk to you about it. Thank you. Oh,
Is Mr. Colson in here with him? He's had, you know, Miss Colson's on the phone. I know she said she's gonna be a little late.
I think she might be covering Judge Allen's room if she's still.
Yeah, I think she said she's coming at 10:30. Mr. Simpson's on his way down. I'm gonna get a PSI. Let's see, we're gonna pick a date for PSI. This is a matter of State of Ohio versus Robert Simpson, case number B2401857. Mr. Simpson is present in the courtroom with his attorney, Ms. Stephanie Lake, and Mr. Brandon Brown from the State of Ohio. This matter is set today for a jury trial, but I have been handed plea documents. Ms. Lake, is this how your client wishes to proceed by way of a plea today?
Yes, Your Honor.
All right, is that accurate, Mr. Simpson?
Yes, Your Honor.
All right. Are you the Robert Simpson named in this indictment?
Yes, Your
Mr. Simpson, how old are you?
Honor.
44? All right. And how far did you go in school, sir? So you're able to read and write the English language well?
Yes.
Are you a U.S. citizen?
Yes.
Have you ever served in the military? Mr. Simpson, I have in my hand a single-page document. It's entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize your attorney's signature right here. Is this your signature here, sir, where it says signature of the defendant? You want to step up and see it?
Yes, Your Honor.
All right. This is an acknowledgement by you that you understand that you have a constitutional right to have a trial, which is set for today. But when you sign this form, you're indicating to the court, I understand that, but I'm waiving or giving up my right to have a trial. I don't want to have a trial. Is that your understanding of what you were doing when you signed this form?
Yes, Your Honor.
Did you sign this form after consulting with Ms. Lake about your constitutional right to have a trial? Do you have any questions about this form?
No.
Do you have any questions about your constitutional right to have a trial? I also have in my hand a 3-page document. It's entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize Mr. Brandon Brown's signature here, Ms. Stephanie Lake's signature here. But up here, this is your signature, and you can step up if you need to.
Yes.
All right, thank you very much. Mr. Brown, would you please put on the record the party's expectation regarding this plea?
Yes, Judge. Expectation is definitively plead guilty to count 1, weapons under disability, a felony of the 3rd degree, as well as count 4, possession of cocaine, felony of the 5th degree. State will be dismissing counts 2 and 3.
All right, Ms. Lake, is that accurate?
Yes, Your Honor.
Mr. Simpson, is that your understanding as well? Sir, are you going to be influenced of any medications, any alcohol or drugs today?
No.
Do you now, or have you ever had to manage any type of mental health difficulties?
No, Your Honor.
Are you presently under any type of probation or community control supervision in this state or any other state?
Yes.
In Kentucky, what's your supervision? All right. Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, Your Honor.
Has anyone promised you anything at all other than the dismissal of counts 2 and 3 if you enter into this guilty plea today? Are you making this plea of your own free will?
Yes.
Now, the state has indicated that it's expected that you're going to enter a guilty plea to count 1 and 4 as charged. That's having weapons while under disability, a felony of the 3rd degree, and possession of cocaine, a felony of the 5th degree. Is that what you talked with Ms. Lake about before this hearing today?
Yes, Your Honor.
Did you have an opportunity to review this 3-page plea form with her before this hearing today?
Yes, Your Honor.
Do you understand what it says?
Yes.
Do you have any questions about it? Do you have any, did Ms. Lake answer all the questions you did have about it? Mr. Simpson, do you believe you had enough time to sufficiently consult with Ms. Lake about your entire case before this hearing today?
Yes.
And has she answered all of your questions to your satisfaction?
Yes, Your Honor.
Have you had an opportunity to review and or discuss with Ms. Lake the evidence, the discovery that the state has against you?
Yes, Your Honor.
Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any to your knowledge?
Yes, the state has turned over all known evidence at this time.
Ms. Lake, do you acknowledge receipt of same?
Yes, Your Honor.
Mr. Simpson, are you satisfied with your attorney, Ms. Lake?
Yes.
Now, do you understand these 2 charges that it's expected you're going to plead guilty to? Count 1, having weapons while under disability, a felony of the 3rd degree, and count 4, possession of cocaine, a felony of the 5th degree.
Yes.
Do you understand that if you plead guilty to these offenses, you are making a complete admission that you committed the allegations contained in those 2 counts of the indictment?
Yes, Your Honor.
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you as to those 2 counts and proceed to sentence you immediately?
Yes, Your Honor.
Now, count 1 being a felony of the 3rd degree, do you understand that you're facing up to 36 months in prison, up to a maximum fine of $10,000? Do you understand as to count 4, possession of cocaine, because it's a felony of the 5th degree, you're facing up to 12 months in prison and up to a $2,500 fine?
Yes.
Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years? Do you understand? And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that? Are you on post-release control in the state of Ohio? Do you understand that if you are on post-release control and you are convicted of a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand? Mr. Simpson, do you have any questions at this time? Because count 1 and 4 are felonies of the 3rd and 5th degree, community control or probation is a possibility. Do you understand that I could place you on probation for up to 5 years instead of sending you to prison?
Yes.
Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control or probation and you violate the conditions of community control, then you would be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time, up to the 36 months on count 1 and up to the 12 months on count 4 that I previously discussed with you. You understand? Also, if I impose court costs and you fail to pay those court costs, I could just order you to do community service instead of paying court costs. Do you understand? All right. Do you have any questions so far?
No.
When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, which is set for today, either to the court or to a jury of 12 persons?
Yes.
Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by a lawyer?
Yes.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify on your behalf?
Yes.
Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at a trial, you cannot be forced to testify against yourself?
Yes.
Do you understand each of these rights as I explained them?
Yes.
Do you have any questions about your constitutional rights?
No.
Do you have any questions about anything we discussed today?
No.
Do you understand that if you plead guilty, you are giving up or waiving all of these important constitutional rights that I explained to you today? Do you understand?
Yes.
All right. Knowing everything the court has discussed with you, Mr. Simpson, do you still wish to enter a guilty plea to counts 1 and 4 of the indictment? Counsel, is there anything further before I accept the pleas? May I hear a statement of facts?
Robert Simpson, on or about April 20th, 2024, in Hamilton County, State of Ohio, knowingly acquired, had carried or used a firearm for dangerous ordinance, to wit, a firearm, and at the time the defendant had been convicted of a felony offense involving the illegal possession, use, sale, administration, distribution, or trafficking in any drug abuse, to wit, trafficking in cocaine in Hamilton County Court, Column Pleas, under case number B07-08986 on December 12, 2007, and at the time, the defendant had not been relieved from such disability under operation of law and legal process. Also, on April 20th, 2024, in Hamilton County, State of Ohio, did knowingly obtain, possess, or use together to control substance, to wit, cocaine in an amount that was less than 5 grams. This was a traffic stop. The defendant at the time had a warrant out for his arrest. So once he was arrested, search incident to arrest revealed the handgun and the cocaine. He admitted as much to the officers in this.
All right, thank you. Anything on those facts, counsel? Do your prosecutor said you did? Is it true? What is your plea to count 1, having weapons while under disability or felony of the 3rd degree?
Good.
What is your plea to count 4, possession of cocaine, a felony of the 5th degree?
Good.
Let the record reflect that Mr. Robert Simpson was present in court with his attorney, Ms. Stephanie Lake, and that Mr. Simpson was informed of all of his constitutional rights, has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Simpson understands the nature of the charges, the effect of the pleas, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty pleas, finding them to be voluntary. The court accepts the guilty pleas and finds Mr. Robert Simpson guilty as charged in count 1, having weapons while on disability, a felony of the 3rd degree in violation of revised code 2923.13, subsection A3. And finding his guilty plea to be voluntary as to count 4, possession of cocaine, a felony of the 5th degree. The court finds him guilty as charged in violation of revised code 2925.11, subsection A. Counts 2 and 3 are dismissed at the state's request. Counsel, is there any reason why Simpson should not be entered today?
We are prepared to proceed with sentencing. The court later to
Well, let me ask a couple of questions. Mr. Simpson says he is on parole in Kentucky. Is there a detainer?
He has an order for parole in Kentucky, and he's expecting a prison sentence. I talked to the parole officer, and the parole board in Kentucky, and a prison sentence is expected on violation.
I see. And will the defense be asking for a concurrent term?
Yes.
Okay, I'm going to be a PSI.
Understood.
All right, so I'm going to order a PSI, pre-sentence investigation report, that tells me a little bit more about you and your history other than what you stand convicted of. And I'll set this out for sentencing. Ms. Howard?
August 28th.
August 28th?
Yes.
All right, August 28th, 9 a.m. Mr. Simpson, someone from the probation department, the PSI division, will come to the Justice Center and speak with you. Please know that they're coming on my behalf, and they will interview you. And they will write a report of their interview of you about, more about, if you have a statement you want to make, but more about your history, you know, where you live, or, you know, your situation. Because I just want to know more about it to make an informed decision. And so we'll come back here on August 28th at 9 a.m. I will share that report, that written report, with your attorney and the prosecutor before the sentencing. Okay? All right. Any questions? All right. Thank you. We'll see you on the 28th next month.
Could everybody please turn your cell phones off? Thank you.
All right. Who's next? Who's this?
Bradford, and the justice division waiver.
Mr. Henry?
Yeah, I got it.
This is the matter of State of Ohio versus Bradford Henry, case number B 2400773.
Judge, that's on us, aspect of them.
Yes.
Okay. Sometimes I go fast, I'm like, I don't remember that.
Thanks. so long. That's great. I've been singing all weekend.
For your festival, Judge?
I went to the Macy's Festival.
Yeah.
You would have thought I was in concert.
My dad and myself, my family, got to as well.
Yeah, I'm a seventh, member of New Edition. All right. Mr. Henry is present in court with his attorney, Mr. Matthew Ernst, Mr. Brandon Brown for the state of Ohio. This matter is set for jury trial today, but I've been handed plea documents. In fact, no contest plea documents. Mr. Ernst, is this how your client wishes to proceed?
Yes, ma'am.
Mr. Henry, is that true?
Yes, ma'am.
All right. Are you the Bradford Henry named in this indictment?
Yes, ma'am.
Mr. Henry, how old are you?
48,
How far did you go in school?
a little bit of college.
So you're able to read and write the English language well?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
No, ma'am, I don't have any.
All right. Mr. Henry, I have in my hand a single-page document. It's entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Mr. Ernst's signature, his bar number right here. But right above it, is that your signature where it says defendant?
Yes, ma'am.
This is an acknowledgement by you that you understand that you have a constitutional right to the trial. But when you sign this form, you're indicating to the court, I understand that, I understand my right, but I'm waiving or giving up my right to have a trial. I don't want to have a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after consulting with Mr. Ernst about your constitutional right to have a trial?
Yes, ma'am.
Do you have any questions about this form?
No, ma'am.
Do you have any questions about your constitutional right to have a trial?
No.
I also have in my hand a 3-page document, and it's entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of No Contest. On the 3rd page of this document, there are signatures. I do recognize Mr. Brown's signature here, Mr. Ernst's signature there, but right up here, sir, is this your signature or is this signature of the defendant?
Yes, ma'am.
All right. Mr. Brown, would you please put on the record the party's expectation regarding this plea?
You know, the expectation is for Mr. Henry to plead no contest to the one count indictment, failure to comply, felony of the 3rd.
Mr. Ernst, is that accurate?
Yes, Your Honor.
Mr. Henry, is that your understanding as well?
Yes, ma'am.
Mr. Henry, are you under the influence of any medications, any alcohol or drugs today?
I am on medication for my heart.
All right, so it's prescribed medication under a doctor's care.
Yes, ma'am. That's correct.
Does the medication in any way alter or compromise your ability to think and comprehend?
No, I don't believe so.
All right. Do you now, or have you ever had to manage any type of mental health difficulties?
No, ma'am, I'm not.
Are you presently under any type of probation or community control supervision in this state or any other state?
No, ma'am, I'm not.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all if you enter into this plea of guilty today?
No, ma'am, they're not.
Are you making this plea of your own free will?
I am, yes, ma'am.
Now, the state has indicated that it's expected that you're going to enter a no contest plea as charged to count 1, failure to comply with the order or signal of a police officer, a felony of the 3rd degree. Is that what you talked with Mr. Ernst about before this hearing?
Yes, ma'am.
Did you have an opportunity to review this 3-page plea form with Mr. Ernst before this hearing today?
Yes, ma'am, we did.
Do you understand what it says?
I did.
Do you have any questions about it?
No, ma'am.
Did Mr. Ernst answer all of your questions about it?
Yes, we did.
Mr. Henry, do you believe you've had enough time to sufficiently consult with Mr. Ernst about your entire case before this hearing today?
Yes, ma'am, I am.
And has Mr. Ernst answered all of your questions to your satisfaction?
Yes, ma'am, he has.
Have you had an opportunity to review and or discuss the evidence that the state has against you with Mr. Ernst before this hearing?
Yes, we do.
Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge, to the defense?
Yes, Judge, at this time, the state has provided all known discovery.
Mr. Ernst, you acknowledge receipt of same?
Yes, sir.
Mr. Henry, are you satisfied with your lawyer, Mr. Ernst?
Yes, sir.
Do you understand this charge against you, count one, failure to comply with an order or signal of a police officer? Do you understand that charge?
I do, yes, sir.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in that count of the indictment?
Yes, sir.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, sir.
Now, this being a single count felony of the third degree, do you understand that you're facing up to 36 months in prison and up to a maximum fine of $10,000?
Yes, sir. I do.
Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years? Do you understand that?
Yes, sir.
Do you understand that if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence?
Yes, sir.
Are you on post-release control in the state of Ohio?
No,
Do you understand that if you are on post-release control and you commit a new felony offense while on post-release control, in addition to being punished for the new felony conviction, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains during the post-release control time, or whichever is greater? Do you understand?
yes, sir.
You have any questions?
No, ma'am.
Since this is a felony of the third degree, community control or probation is a possibility. Do you understand that I could place you on probation for up to 36 months instead of sending you to prison?
Yes, sir.
Do you understand that if I place you on community control or probation, you would have to abide by all probationary conditions as established by this court?
Yes, sir.
And if I place you on probation or community control and you violate the conditions of community control, then you would be brought back before me for a more restrictive sanction, which could include a whole host of penalties, but the most severe penalty could be prison time, up to the 36 months I previously discussed with you. Do you understand?
Yes, sir.
Do you understand that if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying the court costs? Do you understand?
I do.
Do you have any questions at this time?
No, ma'am.
Mr. Henry, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, which is set for today, either to the court or to a jury of 12 persons?
Yes, sir.
Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your attorney, Mr. Ernst?
I do.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you?
Yes, ma'am.
Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that at a trial, you cannot be forced to testify against yourself?
Yes, ma'am. I understand.
Do you understand each of these rights as I explained them?
I do understand. Yes,
Do you have any questions about your constitutional rights?
ma'am. No, ma'am. I do not.
Do you have any questions about anything we discussed here today?
No, ma'am.
Do you understand that if you plead guilty, you plead no contest. You plead no contest. I'm sorry if I've been saying plead guilty. You are waiving all of these important constitutional rights.
Yes, ma'am.
Okay. Knowing everything the court has discussed with you today, do you still wish to enter a no contest plea as charged?
Yes, ma'am.
Is there anything further before I accept the plea?
No, ma'am.
May I hear statement of facts?
Bradford Henry, on or about February 13, 2024, in Hamilton County, State of Ohio, operated a motor vehicle so as to willfully elude or flee a police officer after receiving a visible or audible signal from the police officer to bring his motor vehicle to a stop. The operation of the motor vehicle by the defendant caused a substantial risk of serious physical harm to persons or property. Judges, officers went to initiate a traffic stop. Mr. Henry took them on a chase, crashed red lights, exceeded 90 miles per hour. Eventually, his vehicle flipped over on the side of the road in a car accident, and he was arrested from that point. There is an accompanying or a related OVI charge to this as well.
All right. That has not been resolved.
I'm not sure. It's just set for pre-trial, for the next 2 weeks.
I see.
I can tell you exactly.
No, I have it here, but it's just not resolved yet.
It is not.
All right. All right, anything on the facts, Mr. Ernst?
Something in the back.
All right, Mr. Henry, did you hear the prosecutor said you did?
Yes.
Is it true? What is your plea to failure to comply with an order or signal of a police officer?
No contest.
All right, so I just want to make sure the record is clear because I think I may have said some language regarding a guilty plea when I meant no contest plea. So when you plead no contest, you are agreeing to the facts of the case and that the state is able to prove the essential elements of the offense. You're just not openly admitting that you're guilty. Do you understand that distinction?
Yes, ma'am.
All right, and your plea is no contest? All right. Let the record reflect that Mr. Bradford Henry was present in court with his attorney, Mr. Ernst, and that Mr. Henry was informed of all his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Henry understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the no contest plea and finds Bradford Henry guilty as to count 1, failure to comply with an order or signal of a police officer in violation of Revised Code 2921.331, subsection B, a felony of the 3rd degree. Is there any reason why a sentence should not be entered today?
Judge, when it's for PSI, there's, I want to write a sentence here where there's some substantial mitigation to court.
All right, Ms. Howard, let's get a PSI.
And yes, we have one time, sorry, go ahead.
August 28th.
I was wondering if we want to try anything that has to do with it. If it's possible, Judge, he has hard to choose, and could we do it after September 11th? He has an important medical appointment that we're obviously hopeful that we can continue to see treatment after August 28th, but is that too far out?
Let's see. Correct. Let's see. We got about 30 days to resolve this case, so that's why it's August 28th. So let's just stick with that date for right now, okay? All right,
Thank you.
so, I'll order a PSI. Is there a victim impact on this? I know his car flipped over, was the officer hurt?
Judge, I think that there was an officer whose car was hit. I'm not sure the extent of the damage, but I know it was a single car accident, so I think that would be the element. So,
I think that's the only
yeah.
issue is his car,
I'm
his,
pretty sure,
the guy who get hurt anyway.
No, nobody else was hurt.
All right, well, I think I still need to comply with Marcy's law.
Judge, I would say that that's just
I would
something
think
to
that
check with
anyway.
our officers, yeah.
All right, so let's go ahead and set this for August 28th for sentencing. The other thing I want to know is, Mr. Henry, his, heart issues, did they develop after this, or did he have it when this happened?
So we found out about it due to the accident, and so I'm in a light test, it's heart transplant. So I'm only 20% functional in my heart.
I see, but you didn't know that at the time, that,
We did not, but I did.
oh, I see. All right, so you will need to go to probation, report to probation right after court. They will provide a written report to me, called the Pre-Sentence Investigation Report, just so I'll know more about you other than what you stand convicted of in order to make an informed decision. I will share that written report with your attorney and Mr. Brown, prosecutor, before sentencing, and then we'll come back for sentencing on August 28th at 9 a.m. Okay? All right, thank you very much. All right, I know Mr. Ruffin is ready, Mr. I don't see anybody from Mr. Wood. Huh? Oh, yeah, here it is, Mr. Clinton. And, okay. All right, and then Mr. Coleman, where's this the agenda?
She stepped up the hall for a call, Your Honor.
All right, so what I'm gonna do is I'm gonna talk to Mr. Klingberg, the prosecutor, and I'm gonna talk to you and the prosecutor, okay? All right, come on back, come on. Okay, Ms. Coleman, Ms. prosecutor.
I think so.
But she's just.
Don't know where this, postal is. She doesn't apply.
She came in.
She, yeah.
Oh, I can see that.
Yeah, she did come in. Oh, well, we did see her. But she left out. I thought we weren't ready. I texted her and told her, yeah, jury instructions. Maybe she got them, they were on the desk. Maybe she said she got them. What was it? Mr. Kramer, you want Mrs. Wood there?
She was talking about the officers, Judge. I'll know a little more.
Okay. Can you, You know what? Thank you. You ready? So the new cycle. Ready?
You want me to? Oh, yeah, okay.
Yeah, I'm ready to go right now.
I need to get a couple things. I'll be.
Thank you. Did you see, this, what's her name, and her, she goes, okay, great. To go over, I'm gonna be getting on this posting, so.
Okay,
In the meantime, I'm gonna do something, so.
okay. I'm just hanging around.
Okay, thank you. All right. signatures of Mr. Vanessa. Bring the jury down. Right now.
They're finishing the waiver right now, Judge.
All right, Mr. Goldberg, counsel will be next table.
This is a matter of State of Ohio versus Edward Ruffin, case number B2400562. Mr. Ruffin is present in the courtroom with his attorneys, Ms. Courtney DiVincenzo, Mr. Christopher Coleman, Mr. Brandon Brown is present on behalf of the State of Ohio. This matter is set for jury trial today. Counsel, are you all ready to proceed?
Yes,
State of Ohio?
Yes, Judge.
Yes, Your Honor, we have a jury waiver coming in.
Yes. I've been handed a waiver of trial by jury, a single page document. Looks like it was executed. And I will ask you, Mr. Ruffin, I recognize Mr. Coleman's signature here at the bottom. Is this your signature here where it says defendant? This is an acknowledgement by you that you understand you have a constitutional right to have a jury trial that's set for today. But when you sign this form, you're indicating, I understand my right to a jury trial, but I don't want a jury trial. I'm waiving my right to a jury trial. I want my case to proceed to the court, the bench. Is that what you want to do? Is that your understanding of what you were doing when you signed this form? All right, did you talk with Mr. Coleman and Ms. DiVincenzo about your constitutional right to have a jury trial? And do you have any questions about your right to have a jury trial? Any questions about this form?
No.
All right, it is hereby accepted, and the waiver of trial by jury is going to be filed, and we will now proceed with a bench trial. You may be seated at council's table.
Thank you, Judge.
Any pre-trial issues before we begin?
Not from the state, Judge.
Your Honor, we just request separation of witnesses, please.
All right, separation of witnesses is hereby in effect, it is granted. Do you have a, case officer?
Yes, Judge, Officer Van.
Okay, are you designating him as?
No, Judge, I was gonna have to testify first, but he's not.
All right, all other witnesses that would be scheduled to or anticipate testifying in the Edward Ruffin case would be to step in the hallway. All right, opening statements.
Judge, I'll wait, okay.
I have nothing, Judge.
All right,
Thank you. Thank you, Your Honor. Your Honor, this case is going to be about civil standard for her. She is a prosecuting witness in the case. She made an unrecorded statement to the police. It is not backed by anything else. It's uncorroborated, and now the state's case rests on. That's the only piece of evidence. Edward Ruffin is not a thief. He didn't take Sybil's gun. They spent the night together. Edward comes over to their house. They order food, have dinner, they go to bed. They get into a disagreement over whether or not they're going to be intimate. Edward still stayed the night, got up the next morning, went back to his house. Then everything changes. Sybil, who doesn't want the gun out of her sight, sleeps with it under her pillow, cannot find the gun. She tells the police she felt Edward reaching for it under the pillow in the middle of the night. She has no other evidence, only what she thinks she felt. The police don't record Sybil's statement. It doesn't exist. The police write their report. Investigation over. That leaves the question, what really happened? The evidence is going to show that we don't know what happened to Sybil's gun. Did she have tunnel vision that it was absolutely Edward who took the gun after the disagreement? Or did somebody else have access to Sybil's house? Is Sybil reporting the gun stolen to get back at Edward? There's going to be reasonable doubt, Your Honor, in the course of this trial. And at the end of the trial, Mr. Coleman will get back up here and ask you to return a verdict that is consistent with the evidence presented, a verdict finding Edward Ruffin not guilty.
All right, thank you very much. State for your first witness.
Governor Officer and to testify.
All right, sir, will you please raise your right hand and be sworn? You swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so be God.
I do.
Thank you.
Officer, can you please state your name, spell your last name?
Officer Michael M. H-E-N-N,
Officer, and how are you currently employed?
City of North Colorado Police Department.
How long have you been employed in that capacity?
23 years in North Colorado.
Do you happen to see, you know Edward Ruffin?
Yes, sir.
Do you see Mr. Ruffin in the courtroom today?
Mr. Ruffin seated at the defense table in the white shirt and black tie.
Judge, let the record reflect please identify the defendant.
Any objection?
No, no.
So reflected.
Mr. Henn, how did you come to know about Mr. Ruffin?
If I can refer to my report to the date,
I've got no problem with that.
on February 3rd of this year, Sybil Stanford came to our station to file a report. She alleged Mr. Ruffin took a firearm from her residence.
Did you have an opportunity to speak with Mr. Ruffin about this?
No, sir.
Did you follow a warrant for his arrest?
Yes, sir.
Okay. Did you have any other sort of investigation outside of your conversation with Ms. Stanford?
No, sir.
And did this occur within North College Hill where you're a police officer?
Yes, sir.
Is that within Hamilton County, State of Ohio?
Yes, sir.
Do you have any knowledge about this gun whatsoever beyond what Ms. Stanford told you?
Outside of what Ms. Stanford alleged, no, sir.
Was there ever any firearm recovered in this case?
No, sir, it was not.
Thank you, sir. Judge, I have no further questions.
All right, thank you. Any cross-examination?
Okay.
Officer Henn, I want to talk to you about Edward's cooperation with police. He voluntarily surrendered to North Colorado Police Station.
I was not working at that time. I was not there at that time, so.
Did you take a statement from Mr. Ruffin?
No, ma'am, I did not.
You did not. Do you know if another officer took a statement from Mr. Ruffin?
The report does not reflect that.
So, officer, you've been a police officer for 23 years.
Also, 25 years,
25 years.
23 years in college.
You went to the academy
Yes, ma'am.
and you learned how to do police work there.
Yes, ma'am, I did.
you've learned how to gather evidence,
Yes, ma'am.
how to fill out paperwork,
Yes, ma'am.
and you likely went through the field training.
Yes, ma'am.
Basically, it's kind of like how to become a police officer in real life, outside the classroom.
Correct.
And you learn how to collect evidence,
Yes, ma'am.
how to canvass neighborhoods,
Yes, ma'am.
how to preserve crime scenes.
Yes, ma'am.
And as a police officer, you have access to certain programs or tools that assist in your investigation.
That's correct.
So if you have like a DNA sample, you could run it through a database to see if the DNA pops up somewhere to get a match.
That's correct.
You could run a suspect's background.
Yes, ma'am.
You can see what cars they're registered to,
Yes, ma'am.
if someone's been arrested before.
Yes, ma'am.
You can ask the judge to authorize a search warrant, for a house.
Yes, ma'am.
You get a search warrant for a car.
Yes, ma'am.
You can even get it for a phone or social media.
Yes, ma'am.
So you can look at text messages or call logs.
Yes, ma'am.
And you don't even have to like go that far. You can ask just somebody to give you consent to look in their phone.
That's correct.
And you have a body camera.
Yes, ma'am.
And it records your interactions on any typical investigation.
If it's activated, correct.
And to activate it, you just press the button to turn it on,
Yes, ma'am.
turn it off,
Yes,
and
ma'am.
you just it.
Yes.
It's part of your uniform. Right? it's part
That's
of your
correct.
uniform.
Yes.
Are you familiar with Leads Online?
Yes, ma'am.
It's like a nationwide database, helps law enforcement locate stolen property.
Yes, ma'am.
So if somebody reports an item stolen, you could follow up with that database to see if it's been sold at a pawn shop.
Yes, ma'am.
You can see who's resold them and when they've been resold.
That's correct.
And the seller would have to provide their ID card,
Yes, ma'am.
but you need the make and model of certain goods for that, right?
That's correct.
And are you familiar with Leads?
Yes, ma'am.
That's a statewide system.
Yes, ma'am.
And that's a database for missing persons, if somebody has a warrant, stolen property, things like that.
That's correct.
And if someone reports an item stolen, you can put the identifying information with characteristics into Leads.
That's correct.
So you can help a victim of a crime find their property.
Yes, ma'am.
You were at North College Hill Police Station on February 3rd.
Yes, ma'am.
You were on duty
Yes, ma'am.
in your uniform.
Yes, ma'am.
And Miss Standifer walks in.
Yes, ma'am.
You took her statement,
That's correct.
but we don't have a recording of it.
No, ma'am.
You didn't turn your body camera on.
It's not our department policy.
You didn't get the naked model of the firearm?
Yes, ma'am, I did.
You did get the naked model?
Yes, ma'am, I did. And I entered the firearm was stolen.
We'll come back to that in 1 second. So you did get the naked model of the firearm.
That's correct.
You didn't obtain a search warrant in this case?
No, ma'am, I did not.
You didn't, enter any information to Leads Online to try to recover the firearm?
I entered the weapon as a stolen weapon
Into what programs?
into Leeds, RCIC, and NCIC.
Officer, in the course of your investigation, you write reports, correct?
That's correct.
Investigative reports,
Yes, ma'am.
supplemental reports,
Yes, ma'am.
and you take statements from witnesses and victims.
Yes, ma'am.
And the purpose is to document what happened.
That's correct.
Because these reports are evidence in the case.
That's correct.
And everyone gets a copy. I do, prosecutor, right?
Yes, ma'am.
And you refer to that copy when it comes time for a trial.
Yes, ma'am.
And if something is written down in your report, it's because you have put it there.
That's correct.
If I could approach your honor, this is, I'm approaching with your police report and looking at. Are you familiar with this document?
Yes, ma'am, I am.
Okay. And where, in that document, does it indicate,
First of all, what is the document?
I'm sorry, Your Honor, it is the police report, from North College Hill regarding, Mr. Rutland's case. Dated February, February 3rd, 2024. Are you familiar with that, Your Honor? Are you familiar with that, Officer Hen?
Yes, ma'am.
Okay, and on that, does it indicate that you entered this information into leads?
On the narrative, in the narrative, it states that the firearm will be able to be sold.
And you specifically said you did not speak to Mr. Rutland, correct?
Not that I recall.
Did you make an effort to call him at all, talk to him?
I can't recall. The report does not reflect.
Just one moment. No other questions.
All right, thank you. You direct?
None of them say
All right, thank you. You may step down.
Thank you, Your Honor.
Our next witness.
There's always also been somebody using phone call.
What?
Now he's also in.
Yes. You may release.
Just this time, state will call, civil standard,
All right. Good morning, ma'am. If you wouldn't mind raising your right hand. You swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God. Thank you. You may be seated.
Now, can you please state your full, first and last name, spell out the report.
Sybil Stanford, SIBBLE, STANDIFER.
Ms. Stanford, do you know Edward Rutland?
Yes,
Do you see Mr. Rutland in the courtroom today?
yes,
Can you please, point him out for me? Tell me what he's wearing.
he's wearing a white shirt with black hat.
Judge, let the record reflect you identified for a minute.
Any objection? So reflected.
How do you know Mr. Rutland?
We've been dating on and off for 6, 7, maybe 8 years.
And were you guys like kind of on and off back in February of 2024?
We were on
Now, do you recall an incident that occurred around February 2nd, February 3rd, where you stayed over the night?
Yes.
Can you tell me about what happened? Just start at the beginning of how your night together. Was he at your house?
Yes. I worked a 12-hour shift, so I had Friday evening, I came over that evening, and he spent the night. He got upset because I didn't want to have sex because I was tired of working 12 hours. So we just went to sleep. Woke up that morning, he kissed me back and said, I'll see you in a couple hours. Now, normally, I put my gun underneath my pillow before he goes all the time. He's been there for a year. And after he left, I got up, because whatever room I go into, I take my gun with me because I live by myself. So, I pulled my pillow back and my gun wasn't there.
I'm gonna back up a little bit. Where were you at when this happened?
When I noticed my gun was gone,
Where were you at when Mr. Robbins stayed the night?
he might have,
This was in your home?
yes,
And this is located in Hamilton County, State of Ohio?
yes.
About what time was it that you got off?
I worked 12 hours and I got off at my place me to work at night. That day, I think I was home by 8 o'clock.
Was Mr. Ruffin already waiting at your place?
No, I think I called him, so no, I'll be there in a few minutes. And he might have been there when I got there.
Around 8 o'clock, what did you guys do once you got home?
We had glass of wine. I think he brought some dinner. We might have ate dinner and had glass of wine, watched a little TV.
About how long would you say before you guys went to bed?
Maybe 10, 10:30, 11 o'clock.
Did you go to bed around the same time?
Yes,
When you went to bed, do you remember having your gun at that time?
yes,
Was Mr. Ruffin in the bed with you?
yes,
Do you live with anybody else?
no,
Is there anybody else who has a key to your home?
no.
Do you remember at any point in the night waking up at all?
I was to the bathroom.
Do you remember about what time it was?
It happens all the time, about 2, 3 o'clock.
Where do you keep your gun when you sleep with it?
Under my pillow.
And how do you sleep? Just sort of on your back, on your stomach, just kind of,
I always sleep on my back or on my right side.
when you're asleep, can you feel your gun underneath the pillow?
It depends on which pillow. I have 2 pillows. If I move the other pillow, then I can, but if I have both my pillows properly, I can.
Do you recall if you were able to feel the presence of your gun this night when you were asleep?
No,
When about did you wake up the next morning?
when he got ready to leave, it was about 9:50.
Did he say anything or note to you?
Now he just said, see you later.
Did he seem upset or anything when you left?
No, he never told me that was upset.
Around what time did you think you noticed that your gun was missing?
About 9:30.
Did you ever make any contact with Mr. Ruffin about the whereabouts of your gun?
Yes, I called him, I texted, he did not respond.
Since this happened, has he said anything to you about the whereabouts of his gun?
He keeps saying he don't know what I'm talking about.
Have you ever misplaced your gun?
No.
How many rooms are in your house?
I had 2 bedrooms downstairs and a bedroom upstairs, kitchen, bathroom, living room, and my basement.
Does anybody else live with you at this time?
No, just me and my dog.
Is it possible at all that you misplaced your gun?
No,
Have you ever had any trouble finding it before and then it turned up somewhere else?
no, I always know where it's at.
All right, ma'am, I don't have any further questions, thank you.
All right, any cross-examination?
Thank you, Your Honor. Ms. Sanford, I'd like to start with referencing one of the questions that you just answered for Mr. Brown on direct examination. The evening that this allegedly occurred, you said you were unable to recall if you could feel the gun under your pillow that night. Is that correct, ma'am? Moving on to your relationship with Edward, you two, this happened in February, you two have still been spending time together
We just came back and forth.
and on a vacation, the two of you.
That was the time with my children, my grandchildren.
And you two have been spending time together the whole time this case is pending?
we did that first because we weren't talking after he did it. And then we started contact probably in March or April,
And then since March up until now, you two have been.
on and off, yes.
I want to talk to you about your house.
Mhm.
You have security cameras in your home,
Yes, I do, and
inside and outside.
yes,
You have several cameras in your home.
I have two inside my house.
One in the kitchen, where's the other?
In my living room,
In your living room? You have cameras outside as well.
my hot coach.
Did you tell the officers you have cameras?
Yes, I do.
Did they go get your camera footage?
No.
And Edward's the one, he knows the cameras are there.
Yes.
He's the one who hooked them up for you.
Not yet.
And I know you live alone,
Mhm.
but you do have two adult children.
Yes, I do.
They don't have keys to your house,
No, they don't.
but they do have the garage access code to your home.
So, yeah.
And obviously, you're not with your children all the time.
No,
You don't know who they may have brought to your house on other occasions,
my children don't do that. They let me know.
but you're not there with them all the time.
But I have cameras and I can see if I need to.
I want to go back to the day that's allegedly occurred and run you through that, okay? So the argument happens in the evening.
We never had an argument.
Okay, I'm sorry to disagree. You said you got upset.
I didn't.
There was an incident regarding you two not having sex that happened the evening before this.
That happened that night, yes.
Can you repeat that?
That happened that night, yes.
Thank you. And then Mr. Ruffin stayed over.
Yes.
You didn't kick him out.
No,
Because this wasn't like a big knockout, drag out thing.
no.
When did you first realize that your gun was on?
When I can get my pillow back.
Was that, did you,
That was after the
after, was it after you showered as well?
after.
After you showered as well?
No,
Um, okay, we'll look up that. So let's break that down. So you wake up in the morning, what's the first thing that you do that morning?
and gets me back and he left. And I got up, pulled my pillow back to look for my gun, and it was gone.
Before I ever left that morning, I think I might have turned the microphone off when I dropped the judge. My apologies. So Edward was gone when we left in the morning. Or, I'm sorry, can we back up? I apologize. We're messing with the microphone and I didn't hear your last response. So we're gonna back up just a moment, okay? So you wake up, Edward kisses you goodbye, he leaves, right?
Yeah,
At that point in time, when Edward left, had you gotten up out of bed at all?
I went to the back.
Just one moment, Judge. And this gun, that was something that Edward had purchased for you
He bought me from John Thompson
a couple of years ago,
a year ago.
and he bought the same gun for himself.
No,
He didn't,
not at that time.
he has other products or something.
He had several other guns.
No other questions, Judge, please.
All right, thank you. Any direct?
Sure, Judge.
No.
Ms. Sanford, do you specifically have cameras in your bedroom?
No.
Would you have had any video footage of taking the gun from your bedroom in another way?
I have cameras in my kitchen and it points down my hall, even just to him going coming from the bedroom, always to the kitchen. But I couldn't tell you what he was doing, because it just shows him walking out.
Do you have cameras, showing the entrances and exits to your home?
Yes,
Are those at your doors, front door, back door?
front door and back.
Do you have any at the garage, going in your garage at all?
You know, you can pan it over and you can see the driveway, but you can't actually see the garage door.
Would you be able to see if somebody entered through that way?
My front door. You can see a person walking down my driveway, they go to my garage.
When this occurred, did you remember having your gun back?
Oh, yes.
There's no other questions.
All right, thank you very much. I have a question. This is Standiford?
Standiford.
All right, thank you. You indicated that you and Mr. Ruffin have had an on and off relationship for 6 to 8 years, and recently you've been on.
Little.
All right, so you just returned from Florida together? So as you sit here today, is your relationship on or off?
It was on until we came back from Florida. We kind of wanted vacation in Florida.
So it's off today?
But not since we came back.
When was that?
We came back the 21st of July. We were there the 16th of June.
So about a week. It's been on for about a week. All right, any questions? That's all, thank you, ma'am. Any questions based on what I asked?
Nothing, Judge.
All right, thank you, ma'am. Ms. Second. All right, call your next witness.
Judge, this time, state the rest.
All right, thank you very much. Defense?
We have one more, please. We have no witnesses, Your Honor.
All right, do you have a motion?
Yes, Your Honor, we would move at this time for involuntary dismissal. The state has not presented, this is just a bald allegation, without any corroborating evidence whatsoever from an upset girlfriend. There are video cameras in the house that are not permitted, Judge. They presented truly no evidence. We ask the court to grant the request for involuntary dismissal.
All right, thank you, state.
Judge, Rule 29 should be viewed in the light most favorable to the state. In this instance, Ms. Vandenberg's testimony is really the only thing that the state is presenting here. If the court would believe her credible, she had her gun that night, nobody else had access to her home. It was gone once Mr. Ruffin left. That is enough to overcome a Rule 29 motion, so the motion should be denied.
All right, Mr. Brown is accurate with regard to his statement about the law. The court is compelled with this posture of the case to view the evidence in the light most favorable to the state. Given that, the Rule 29 motion is denied. All right, you ready for closing?
Yes, Judge.
All right, Mr. Brown.
Judge, the facts of this case are pretty straightforward, and the evidence that the state is relying on is really just the testimony of Stanford. She immediately reported the gun stolen once she realized what happened, and she told her story very truthfully while she was up here. There were facts that she may not have wanted people to know that may have seemed bad for her, and at no point did she try to make anything up or mitigate those facts. She admitted, I had a relationship with Mr. Ruffin. She admitted it's on again, off again. She admitted that during the pendency of this case, she has continued a relationship with Mr. Ruffin. She admitted to things that she couldn't remember and other things that she didn't know. Based on that, I think that her credibility links to the fact that her story is true, that she did have her gun that night. The only other person that was in her home that night was Mr. Ruffin. And the next morning when she awoke, it was gone. If those facts are true, the only person who could have taken the gun is Mr. Ruffin. He's the only one who's there. She remembers having it that night, and then the next day it's gone. It's circumstantial evidence, but if all those facts are believed to be true, then the only conclusion it comes to is that Mr. Ruffin did in fact take the fire. It's for those reasons that the state is asking that you find Mr. Ruffin guilty of felony 3 theft of a firearm.
All right, thank you. Defense?
Your Honor, Mr. Ruffin didn't take anything from Ms. Hannaford, and the state certainly didn't meet their burden today during the course of this trial. This is completely unsubstantiated and uncorroborated allegations. That's all it is. We have an upset girlfriend accusing her boyfriend of doing something wrong with literally no evidence to support that. And I think it's important, Judge, to note that the reason that there's no evidence to support that is because of decisions made by both of the state's witnesses today. Ms. Hannaford has cameras in her home and outside of her home that monitor who's in there, who's out there. She testified that that was provided to, or that she made aware the officer investigating the case, saying there are cameras on. No one went to go get those to say, hey, what went down here? Was there anyone else here in this house? She testified that she has a garage code that her children have access to her home. No one bothered to get the footage to look into that whatsoever to see if anybody was there at the house. Now, I don't know, frankly, if Ms. Hannaford is lying or she's making an assumption because she had a disagreement with Ms. Hannaford or with Mr. Ruffin. And that's because the state didn't investigate this case properly. They didn't get a search warrant for his home. They didn't go through any messages between the two of them. They didn't even bother to record Ms. Hannaford's statement so that we would all have the benefit of reviewing that for consistency and accuracy. They did literally nothing. I know the court's well aware of what the law is, so I won't beat a dead horse, so to speak, but it obviously is the state's obligation, the state's burden. And there are numerous explanations of these events and these allegations that are reasonable and consistent with Mr. Ruffin not having done this. First of all, I mean, there's really, like, honestly no evidence that, compelling evidence that the gun ever even existed. There's not a single photograph, there's not a single receipt, there's not a single thing to prove that this gun was ever even real. Those are things that the state couldn't provide and didn't provide. She could just be making this up full cloth. She could, if that could be real, she could be making up the fact that Mr. Ruffin took it. She could have misplaced it. Somebody else could have gone into the house while she's in the restaurant. We simply don't know, Judge. Mr. Ruffin is entitled, he has a presumption of innocence and the requirement that the state prove the case beyond a reasonable doubt, Judge. And just one person saying, I think you did something, without any other evidence to corroborate that, simply doesn't meet that burden, Judge. We'd ask you to find Mr. Ruffin out.
All right, thank you. Anything else from the state?
No, Judge.
All right. The court will take a recess for a few minutes, consider this, and I will be right back. All rise. You can see this.
Okay, so just with videos that we talk about just really oh yeah. You know, so what I'm having burn there's the one I'm thinking and then I know all these sessions, which is putting like a 1 second class for you. repeat footage on the show footage before the scene. Lower scene walks across the lower scene. During the standard part of the scene. It's basically is there. This action, and then once it starts being like, okay, that's what's. That's,
All right, you need to see it. The court has reviewed the matter. It's a very short trial, and I took copious notes. The court approaches this case with much empathy and willingness to understand both parties' perspectives. The court has to take that empathy and willing to understand and balance it with the rule of law. The court is obligated to follow the rule of law, and in doing so, I must consider and pay due consideration to the elements of the offense, which the state is obligated to prove beyond a reasonable doubt. After viewing the evidence presented by the state, I have a single witness, eyewitness, who didn't provide any evidence that she saw or perceived the defendant actually take the firearm. And the court gave consideration to the history of the parties, the context and specific facts of this case. Given that, the court finds that the state is unable to prove beyond a reasonable doubt that all the elements of the offense effect were met. Accordingly, the case, I find Mr. Rugged not guilty. Case is hereby dismissed. Thank you.
Thank you, Judge.
All right, Mr. Goldberg, you waited patiently. I know Mr. Klingberg, I'm gonna have you come and I'll talk to you and Mr. Brown, but I'm gonna have the parties who are ready for trial come on to the council's table. That's the Thacker case.
August fifth. August fifth. Wait a minute. Yes. And pictures.
Yeah.
Great. That's next week. This is on the
Yeah.
Yeah. Thank you. That's late.
I don't know any basic content, I didn't copy. I don't know how much else.
Well, thank you. That's.
Yeah. I don't know how much you want to do with this.
That's how we do the 12. Yes. Yeah. It's not on Tuesday. Your favorite instruction Tuesday.
Well, if you're coming from out of town, it starts on Tuesday.
Okay. You can do 12. Can you take 12?
Good, I'll probably have somebody maybe cover for me, I do have a protocol. 12, not administrative. And that, I think.
At this point,
Okay. August 12th at 10 a.m.
I think he's okay, I'll run up. I can see what it does.
Well, we'll go right and see that, and there's some issues with that. Thank you. Wait, time, wait.
Yes.
All right, council, do you want to get started and we go to 12:30, or do you want the jury to go to eat? And, what do you want to do?
We do have at least one freestyle matter among the community last time.
Well, then we need to, let the jury go to lunch. Now, the thing is, I'm not gonna not eat lunch, and neither is my staff. So is this gonna be quick, or do we need to just recess and then come back after everybody comes back after lunch?
It's pretty quick, actually.
And well, you guys say that all the time.
The state of Ohio also filed a motion to eliminate judge.
So we got two motions in limine that we need to deal with.
I have an extra copy that makes it easier for.
Are these quick motions in limine, do you think, or do we just need to all go to lunch and come back fresh?
I think mine's relatively quick, and there's maybe one. There will be one.
Because I want to give my team an opportunity. They've been working since 8:30. I don't want them to go through lunch not eating.
I mean, Judge, I don't know, whatever is your pleasure, I'm happy to do whatever.
All right. I have the jury go to lunch to one of the teams, Howard. We'll start promptly at 1:15, so they should be back and be ready to go at 1:15. All right. I think we probably should go ahead and have this go to lunch, give my team a break, particularly what reporter has been going, we just had a bench trial. So why don't we break, till 1:00? The jury will come back at 1:15. All right?
Very well, thank you.
All right, thank you, and then we're gonna, and hopefully you're set up and everything, the courtroom will be secure, we'll lock the door. Okay, and we'll be ready at 1. Thank you.
Thank you.
Yeah. You know.
So what you get for that? I don't remember.
I got a whole meeting, jury. Oh. Look, I had 2 cheese cones last night. It's how.
Okay.
It's pretty full.
Wait, Lopez, slow down. The rest of my team is on their way. We should wait.
I got a nut with a gun in a hospital full of kids. If you want to wait, wait.
This morning it didn't come up at all.
No.
Nope, it did not. What is this thing?
Is it taken down already?
Oh, I was trying to do it now. It's just, I can't get to it. What in here? Okay. Go back there. Here it go, here it go. It wouldn't even let me get to that. Wait.
Oh, sorry.